Hello everyone, this is Mike with a two-way report. Let's discuss a significant update in a legal case that seeks to lift the prohibition on buying and owning suppressors in a particular state. In this video, we'll take a look at a lawsuit that seeks to eliminate a ban on owning and buying suppressors in the state of Illinois. The case we'll talk about is Anderson V Raoul. It was filed on the 27th of February of this year in the Southern District of Illinois. Its main objective is to overturn the ban on suppressors enforced by the state of Illinois. Some of you might be wondering, what's the big deal with the suppressor lawsuit? And you know what? I would ask the same thing too. There are a total of 42 states in the US that legally allow the purchase, possession, and use of suppressors. If you're asking what the big deal is with this case, you probably live in one of the 42 states that do allow suppressors. Currently, 8 states restrict their citizens' constitutional right to own suppressors. Among the states with the strictest gun laws is Illinois, the stronghold of anti-Second Amendment lawmakers and law enforcement personnel. Illinois has a ban on NFA firearms and has mandatory ownership permits and firearm purchase waiting periods. Now, in Illinois, there are over 2.4 million firearm owner identification or FOID card holders, responsible gun owners who have a valid use for a suppressor. A huge chunk of those 2.4 million are first-time gun owners, and they frequently ask whether suppressors are illegal in the state because, contrary to all the BS being peddled by Hollywood, suppressors do have lawful practical uses. Sadly, whenever someone asks if suppressors are illegal in Illinois, the quick answer is yes. They are banned throughout the state of Illinois, but the outcome of Anderson V Raoul could potentially change that. And if our friends in the remaining 7 suppressor ban states are lucky, they might follow suit. The Anderson lawsuit springboards off of the recent ruling of the Supreme Court in New York State Rifle and Pistol Association Inc. v. Bruen. In Bruen, Justice Thomas struck down the state of New York's May-issue CCW licensing scheme, stating that it was not consistent with the country's history and traditions. A significant outcome of the Bruen ruling was that the government must demonstrate that its limitations align with the history and tradition of the United States. The Anderson lawsuit seeks to challenge Illinois' ban on suppressors by requiring the state to demonstrate how the ban is consistent with the Heller and Bruen rulings. The plaintiff argues that suppressors are commonly used and owned by law-abiding citizens for lawful purposes and should not be considered dangerous or unusual. As a result, they cannot be banned by the state. It is significant because it has been firmly established that the Second Amendment protects modern firearms, not just muskets, as some anti-gun advocates argue. In the legal community, the claim that only muskets are protected holds no weight. The Supreme Court reaffirmed this point in Bruen. In Heller, it was recognized that the Second Amendment's historically fixed meaning applies to new circumstances. The reference to arms in the Second Amendment is not limited to those arms in existence in the 18th century. The Supreme Court has held that just as the First Amendment protects modern forms of communication and the Fourth Amendment applies to modern forms of search, the Second Amendment extends to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding. Therefore, while the second definition of arms is fixed according to the historical understanding, the general definition encompasses modern instruments that facilitate armed self-defense. The argument that suppressors are not protected under the Second Amendment because they did not exist during the founding is considered irrelevant in the Anderson v. Raoul case. The plaintiff argues that suppressors are not dangerous and unusual, and their mere ownership cannot be equated to owning a dangerous and unusual item. Instead, suppressors are commonly owned by law-abiding citizens for lawful purposes and fall under the category of bearable arms. Therefore, according to the rulings in Heller and Bruen, a state cannot completely ban the possession and use of suppressors as they are commonly used for lawful purposes such as noise reduction in self-defense situations. Unfortunately, this Anderson lawsuit has hit a roadblock, as the judge has stayed the case for 90 days due to another lawsuit challenging the state of Illinois' ban on so-called assault weapons. According to the court order, this case was filed on February 27, 2023, and on February 24, 2023, the court consolidated 4 cases related to the Protect Illinois Communities Act. The court also set a briefing schedule and scheduled oral arguments for the pending motions for preliminary injunction at that time. There is no pending motion for a preliminary injunction in this case, nor have the parties attempted to consolidate it with the pending cases. However, the court has the authority to stay proceedings as part of its control over its own docket. Based on the potential impact of pending motions in the lead case on Anderson, the court concludes that a stay of these proceedings for 90 days is appropriate to avoid any unnecessary delays. All pending matters are to be held in abeyance during this period. So, in case you're wondering, the court in the Anderson case is currently holding the case from proceeding further due to the pending lawsuits that challenge the state of Illinois' ban on so-called assault weapons, specifically the Anderson V Raoul case, which could potentially impact this Anderson lawsuit. The judge believes that the decision in the assault weapons ban cases could have an effect on this suppressor case and has, therefore, stayed the proceedings for 90 days until the preliminary injunction request is resolved. Curiously, there doesn't seem to be a single assault weapons lawsuit, even the Barnett case, that specifically mentioned a challenge to the state of Illinois' suppressor ban. We went over the complaints in the Barnett case and found zero reference to the state suppressor ban except for flash hiders or flash suppressors falling under Illinois' assault weapons ban. But maybe that's it, flash hiders or flash suppressors. I'm not 100% sure, so don't quote me on this, but there is a possibility that the judge in the Anderson suppressor lawsuit thinks that if Illinois' ban on flash hiders is found to be unconstitutional, then that would be really impactful on the state's suppressor ban, which consequently would also be really impactful to this Anderson lawsuit. What it looks like to pundits is the court seems to be connecting the ban on flash hiders with a ban on suppressors. This is a significant development that could have a positive outcome. The court's position suggests that flash hiders and suppressors are comparable items and that a ruling on one would impact the other. Therefore, a favorable decision on flash hiders could potentially nullify the suppressor ban. This linkage between flash hiders and suppressors also strengthens the common use argument. If the judge sees the similarities between flash hiders, flash suppressors, and suppressors, then it can be argued that they share a common purpose and usage. It is evident that they are widely owned and used by law-abiding citizens, not just in Illinois but in other states as well, which means millions of people own these muzzle devices. And if the judge is linking flash hiders, flash suppressors, and suppressors together, then it can also be argued that the ban on flash hiders could also impact the suppressor ban. But I wouldn't celebrate too soon, as this interplay between the flash hider ban and the suppressor ban could backfire. It could have negative consequences for the Anderson suppressor lawsuit, such that if the judge upholds the assault weapons ban and the restriction on flash hiders, assuming he looks at all these muzzle devices the same way, then there's a pretty good chance that this Anderson suppressor lawsuit will be dismissed. This situation is intriguing and has the potential to have wider implications beyond the state of Illinois. The outcome of the assault weapons lawsuits in Illinois will determine how the suppressor lawsuit proceeds. For the time being, the suppressor lawsuit is on hold for 90 days until the preliminary injunction is resolved. So, what's the big deal with this lawsuit? Well, lawsuits like this could have a nationwide impact due to the court's connection between flash hiders and suppressors, which could assist with future challenges to suppressor laws and other state bans on suppressors. The outcome of this case could potentially have national implications, as it may impact challenges to suppressor laws, bans on suppressors in other states, and even a challenge to the National Firearms Act itself. This case is particularly noteworthy because the court is drawing a connection between flash hiders and suppressors, which could strengthen arguments related to their common use. It is therefore important to closely monitor this case and its potential implications. And we've reached the end of this video. For more updates on Anderson V Raoul, comment down below. If you care about your rights under the Second Amendment, or if you have families and/or friends in Illinois who do, spread awareness by sharing this video with them. Please help the channel grow by clicking on the like, share, and subscribe buttons, and click on that notification bell too while you're at it. Thanks, and have a